Hi, welcome to the podcast, HOA HELL. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Morning, Mike. How are you?
I'm fine, thank you. Sam, today we're going to talk about an issue that's been trending for the last few years, and it's gone hot and cold here and there, but it's hot again for some reason. Maybe it's because summer's coming up, a couple months, and so we're into what some people would call the pickleball season.
Oh, yeah.
And that's what we're going to talk about today is pickleball and tennis, but mostly pickleball. And specifically, HOAs across California converting existing tennis courts into pickleball courts. Now, we're not talking about the portable nets that people can bring in from the garage, stick on a tennis court, play pickleball, and then take back. We're talking about permanent conversions where they actually take the tennis court net away. They might even remove the poles, and then they permanently install.
Surfacing. And the surfacing, too. The lines and the way they oriented the court. Yeah.
Right. And so that's what we're going to talk about today. And it's a hot issue because pickleball, at least in California and maybe nationwide, but I know for sure in California, is the hottest or fastest growing sport around. And it is popping up everywhere. So it seems like a good topic, and it seems like it's gonna touch a lot of our listeners' lives in some way or another, whether you're a pickleball fan or a pickleball non-fan. I think this show will be interesting today. Absolutely. So let's start with the most basic question, and that is, and by the way, I did write a fact sheet on this that I published last week, and I will put a link to that fact sheet in the description for this episode. So does an HOA board have authority to convert tennis courts into pickleball courts without membership approval? Is the first question I want to address. And I'll handle that, and then we'll go on with our discussion.
Okay.
And the answer to that is, in most cases, yes, they do. But it does depend entirely on whether your HOA's CC&Rs have a provision or not that requires the HOA to get membership approval if there's a fundamental alteration in the use or scope of a common area amenity.
That's right.
And because most CC&Rs don't have such a provision, my answer was, in most cases, yes, your HOA does have authority to convert tennis courts into pickleball courts. But that's because recreational facilities like tennis courts and pickleball courts and horse riding and other stuff like that generally fall under the category of common area that an HOA board has broad authority under the Davis-Sterling Act to regulate and control.
By way of operation rules and
exactly
all of those things, yeah.
So absent, and we're going to get to examples of this because there are a lot, absent explicit language in the CC&Rs that state otherwise, an HOA in California very likely has authority to restripe existing courts, for example, modify recreational use from one use to another use of an amenity, convert, and we're talking about courts, convert pickleball courts into tennis courts or vice versa, and repurpose other recreational amenities. For example, they could remove a workout room or a gym and create like a small movie theater if they wanted to, in most cases, okay? And what would control that would be what usually controls board behavior. What's the biggest thing that we've got?
The business judgment rule.
Okay.
Yeah.
I will put a link to one of our many, many fact sheets about the business judgment rule in the description, and I'll put a link to a prior episode of this podcast that we dedicated exclusively to the business judgment rule. But real briefly, 30 seconds or less, tell me what the business judgment rule is.
Well, if a board, these are layperson volunteers, act reasonably for their role in espousing, enforcing governing documents and making decisions that are for the benefit of the membership, then they're entrusted and they get the presumption of those decisions being deemed as reasonable conduct
Exactly.
by these boards. Yeah.
It's a presumption that can be waived or wiped away, but it is a presumption, okay? And that presumption is set forth in the Corporations Code, 7231 as I recall. But it's not blanket immunity to do whatever they want.
No.
However, it is a powerful protection for HOA boards. And as long as they're acting within the course and scope of their authority, they act in good faith, and they aren't committing intentional torts or grossly negligent conduct.
Or waste.
Right. Their decisions are going to be protected. Now, there are some CC&Rs that expressly prohibit the board from entering or engaging in material alterations to the common area without membership approval. That prohibit an HOA from eliminating existing amenities without homeowner or membership approval. That will prevent an HOA board from eliminating or repurposing recreational facilities without a vote of the membership, or even removing common area components. And I want to give a few examples. Since we're talking about pickleball and tennis primarily today, I'll start with the tennis one, and then you give me one that we see around here sometimes. And that is, there are several communities, for example, in Palm Springs is a great place to start, where they have resort-like amenities and where tennis courts are so ingrained into the function. Tennis is such a big part of the common area component and amenities that are offered to homeowners there that their CC&R specifically require the HOA to maintain the tennis courts and not eliminate those without approval of the membership.
Right.
Because they are tennis communities. They aren't pickleball communities. Now, if the membership voted to convert some of those courts into pickleball courts, they could, of course, do that. For every tennis court, you can fit 2 pickleball courts, standard size. Pickleball court takes up a half of a court. So you could conceivably have 2 courts on every tennis court, okay? But in a place like Palm Springs, you're going to find certain communities where tennis is so ingrained into the ethos of that neighborhood that we've seen in those governing documents, in those CC&Rs, we've seen strict prohibitions on what the HOA could do. So in a community like that, they wouldn't necessarily be able to do this.
Right.
Do you have another example?
Well, here in South Orange County, you see a lot of horse-friendly communities. So you have equestrian-type communities where stables and things pertaining to horses and horse ownership is popular. People buy with that expectancy of having those amenities.
They're actually buying with the barn and everything.
Exactly. Yeah. So that's an example of it.
And we see that and I haven't looked at the last time I looked at the CC&Rs for Nellygale was years ago, so I can't remember, but I would be surprised if the Nellygale CC&Rs didn't have very specific language barring the HOA from eliminating, horse properties because people, a lot of those properties are large and they actually are designed to be horse properties.
Exactly.
And you see in San Juan Capistrano, same thing here. In San Juan Capistrano, there are HOAs that specifically require the maintenance of those horse properties and would not allow an HOA to materially alter those uses.
In San Diego County, lots of it.
Rancho Palos Verdes. There's multiple HOAs there to protect the horse character, the I don't know the word for that. The
equestrian?
Equestrian, that's the right word. The equestrian character of certain communities. So that's what we're talking about. And there is a distinction, by the way, between modifying a recreational use and eliminating in a longstanding use. There is a difference. One is more extreme. I think elimination is more extreme. Anything you want to add to that?
No. I mean, I'm sure we're going to get into it, but there's also dynamics where we have a mixed dynamic where you have, let's say, the tennis courts partially being preserved and partially altered or repurposed, and we'll get into all of that. No,
let's get into it now.
Okay.
What are you leading to?
Well, in those cases, unless there's a strict prohibition against the repurposing, it gives, under that business judgment rule that we alluded to, it gives the board much more latitude and makes their position and repurposing or alterations more defensible.
Agreed. But I actually think, and there's no bright line here at all, so this is kind of like, who knows, I think it's a sliding scale and it's a case-by-case basis. It's fact-specific. But I think an HOA, even without specific language barring them from conversion without membership approval, I think an HOA would have a harder time. Let's say your HOA has 4 tennis courts. I think your HOA would have a harder time converting all the tennis courts into pickleball courts than they would being able to convert 2 of them into 4 pickleball courts.
Absolutely. Agreed.
Eliminating entirely is more extreme than repurposing partially. So I don't know if it would be reasonable, even in the absence of governing documents like you find in Palm Springs or Nellie Gale or Palos Verdes, even in the absence of specific language barring an HOA from repurposing or converting or eliminating, I think an HOA that has multiple tennis courts would have a harder time getting rid of all of them than just some of them. And so a lot of HOAs have done that. I know, for example, there was a big fight. We represented a group of homeowners in this community, and we got the HOA board to do the more reasonable thing. But over here by and I'm not going to name the HOA, but over near Codo, there's a community that where the board wanted to fight to convert all the tennis courts into pickleball courts. We got them to convert some and to preserve others is what we did. And actually the big dispute there wasn't the conversion of all, it was really the noise issue. And we got them to agree to more reasonable hours, which we're going to address in a minute. Okay, so let's assume for a minute. And by the way, you hear this all the time in opposition. Let's say that there's no language in the CC&Rs that requires the HOA to get permission. So under our scenario, they probably already have the right to do it. You hear people say, but what about the fact that I specifically bought into my HOA because it had those tennis courts? That might be true. It's not going to be enough. The business judgment rule is going to overrule that. Okay, they have the right to repurpose.
And again, we said this unless you have the backing of the governing document specifically.
Well, yeah, but this is specifically when that isn't there.
Exactly.
I did preface that. Okay, so now let's get to the next thing. Let's assume now that a conversion is an authorized conversion. Okay, either because the HOA has sought and acquired what it was required to get from the governing documents, or they didn't need to seek membership approval and they have properly taken the steps to repurpose 2 of the 4 courts into pickleball courts. So I'm assuming for this next part that their conversion is authorized. That doesn't mean that there are not going to be problems. Pickleball is a very different game than tennis for a lot of reasons. The most important and common reason, and the most important and common basis for objections to pickleball is what? Noise.
Far louder.
Much louder. For those of you who are familiar with tennis and pickleball, you're nodding your heads. Pickleball, by nature of the racket that is used and what the ball is made of, it is a much louder sport. Not even a little louder, much louder. It's a loud clap versus a thud. And here's the thing. There is technology out there. There are rackets out there and there are balls out there that reduce that noise difference. But they're expensive and most people don't have it. So it's not like the game doesn't recognize that, but it's not the norm yet. Okay, the technology is still, it makes the equipment a little more expensive. So most people don't have it. They have the less expensive versions. And that's the problem. Not only is it louder, but it's a very distinctive, loud, popping, clapping sound.
I think it travels quite a distance too.
I think it does travel more. For those of you who haven't seen a pickleball, some of them, I guess the less expensive ones, look like giant wiffle balls, sort of, right? They have the holes, or the protrusions.
They do.
Okay, now, in addition to the fact that it is just a lot louder, again, not a little louder, a lot louder. I mentioned this before. For every tennis court, you get a multiple of pickleball courts. Otherwise, you'd be wasting space. Okay? So you are now multiplying the amount of people that can play in a given area, which affects parking. It affects just environmental noise, just the amount of conversation, and the amount of people. It affects the use of other common areas like the streets and, wear and tear. You are increasing sometimes twofold, and depending on how many conversions, 2, 4, 6-fold.
Yeah.
The amount of people, cars, the pollution, the noise, all of that goes up commensurately. So there is a built-in increase in impact.
It definitely amplifies it in
every way.
Yeah.
In every single way.
Yeah.
Also, I don't know if you are a pickleball player. I'm a tennis player. I played pickleball.
I've played both.
But I'm a tennis player. I play regularly. One thing that we don't do in tennis that is ubiquitous in pickleball is music.
Yeah.
Tennis is a more quiet sport. I've never seen a pickleball player or pickleball people not have the radio playing music. It is just part of their ethos. Golf and tennis, no music. Pickleball, frequently music. Now, again, this isn't scientific. This is my personal experience, but I belong to a tennis club, and there are pickleball courts there, and they have music. We don't, and it is ubiquitous. So it is enough to be, and plus we've seen people come in with this complaint. The music can be loud. It's often whatever the people that are playing like, but it adds to the noise because now it's conversation. It's the slap of the pickleball and the racket. It's the increased cars or motorcycles and the increased pollution, and now the increase in sound just based on music. Those increase a lot. They multiply the noise and usage impact of a given area.
They do.
By definition. And then, of course, pickleball seems to have extended hours beyond tennis for some reason. Usually you see these hours go later than they used to for tennis. Not always, but we've seen that a lot. That's what we've seen in real life, real world experience coming into our office. I don't know why, but
here's a guess.
Give me a guess.
Could be a function of the age range that can play pickleball easily.
That's a good point.
It's young kids all the way through senior citizens,
Anybody
including
can play.
Senior communities. So, and with a rapid rise in popularity, that could be a big
with
part
the
of it.
risk of offending pickleball players, I do want to say this because I feel compelled as a tennis player to say this. Pickleball is the sport that I intend to go to when I can no longer effectively play tennis. Here's the thing, though. Imagine you live relatively nearby your tennis courts. It's a different noise and impact scenario with tennis than it will be with pickleball. And now suddenly what was tolerable or even not noticeable becomes noticeable and intolerable for those homes, especially if multi-family living, condos, townhomes, that sort of thing, that are centered around, let's say, a court or series of courts.
Windows, bedroom windows facing them.
Balconies,
proximity.
whatever. Exactly. Now we start getting into nuisance disputes. Now we start getting into excessive noise, excessive, light pollution.
Light pollution, even,
right?
yeah.
All right, because those are bright and understandably, and that's when boards can't simply stand back and ignore this. These are things good HOA boards are going to take into account when they are making the decisions about conversions.
Yeah.
They should be thinking about these things, not just do we have a right to convert tennis into pickleball. It's, okay, if we do have the right, what can we do to minimize any negative impact that it could occur? Because there are impacts. We talked about them just now.
Absolutely.
Multiple impacts, okay? And these are real nuisances. And by the way, they can really affect somebody's right to quiet enjoyment of their property.
Absolutely.
If you have to listen to the constant slapping and clapping of those balls all day, it wears on you.
Oh, yeah.
Okay? So HOAs need to take stuff like that into account. And what are some things an HOA can do to help? Look, we want to do this. We want to make these partial conversion. We're going to turn 2 of our courts into pickleball, and we'll keep the other 2 tennis courts. But we also need to respect and honor everybody that's going to be experiencing the increased use and impact. What can they do to help with that?
Well, adopt and implement reasonable rules as far as hours of operation.
Right.
That by extension will impact things like lighting too, because beyond a certain hour of the day or late afternoon, those can be shut off. They can
and those can be set by computer, so that it can't be overridden by people that want to jump the fence.
Right.
You could have the lights go on and off automatically. You could have even gate card access. You could have the gate cards only work during specific hours.
Exactly.
Right?
Exactly.
Go on.
Yeah. One other thing they could do, and this is kind of common with pickleball from what I've heard, is competitions. Make sure that you are not creating that kind of dynamic that invites, including elements from outside, where people will come in to compete or have different.
You see a lot of more
hosting,
contests.
Yeah, contests being hosted, things of that nature. So that kind of mitigates foot traffic, vehicle traffic, things of that nature.
I just thought of something else. Tell me if, and this just occurred to me just now for the first time. I've never thought about this before.
Okay.
When you just said that, you remember that episode we did where we talked about how the ADA doesn't apply
Yeah, I did.
to HOAs unless the HOA opens up
For
its
commercial
facilities
activity or
to
rent.
the public,
Exactly.
to non-members. If you, in a pickleball scenario, start inviting outsiders in to come use your courts as part of a contest or whatever, you've now subjected the HOA to increased liability under ADA, for which you better have appropriate insurance.
100%. 100%.
It just occurred to me that could be an issue.
No, that's an excellent point. And so that can have a tectonic, set of ripple effects in terms of insurance, nuisances, parking-related issues and disputes, perhaps other types of altercations,
security, crime.
Exactly. Yeah. The wear and tear on your turf and surfaces,
and not to mention noise and light and all that other stuff we were just talking about.
Yeah.
So so limiting hours, limiting or controlling outside. It maybe saying, look, if you want to have contests amongst yourselves, fine, but we're not going to allow outside contests. That's for a commercial club. Okay. Sound mitigation measures. Let me give you an example.
Yeah.
When people think of tennis courts, they think of they don't just think of the chain link fence. They think of that green screen stuff. Okay. That green stuff that they connect to chain link fences in tennis courts are not just visual blocks of what's going on outside. They do have sound dampening technology built into it. That sound dampening technology that works for tennis doesn't work for pickleball. There are additional things that an HOA can hang on the fences to muffle or reduce the sound of the pickleball. As we said, is much louder. So they might think about some sound dampening technologies. They might even say, hey, we know that this stuff out there, these different rackets and different balls exist. You must use that equipment if you're going to use our pickleball courts. They could do that.
It's hard to enforce, but yes, they could.
It would be harder to enforce, but it could be enforced.
Yeah.
I'm just spitballing.
Yeah.
Certainly sound dampening tech, like if you look at our walls in our studio, we are outfitted ceiling, walls. Well, the floor doesn't need it because it's carpeted, but every single square inch of this office, including our door, is covered in different sound baffling technology. There are things you can hang or put on fences to help keep sound in. That's probably the more reasonable use.
Yeah.
But you could also require the more sophisticated balls, let's say, or sophisticated rackets. Yeah, he's right. It would be harder to implement. You could also, limiting the hours would also limit the lights, right? During the summer, you might have a little bit of extended time, but you might not start as early in the morning, but you go a little later, stuff like that.
You mentioned music. What about limiting boom boxes and things like that, perhaps? I don't know.
See,
not sure.
Barring people from having music at pickleball would be like a big deal because it's so ingrained into pickleball, but you could do that. You could certainly have limits on volume. You could have rules that say it has to be at a reasonable volume. And what's reasonable? Well, it's what the objective person's going to say. You could say, look, be polite, keep volume. If somebody asks you to turn it down, turn it down.
Right.
You could have rules that require you to be, courteous. Harder to enforce, but at least they'll be there.
And there's a basis for them to follow up on and enforce.
Exactly.
Yeah.
There's something for them to get involved, something to get a hook in. Okay? Remember, guys, these kinds of nuisance complaints, it's too bright, it's too loud, the hours are too long, there's too many cars. These are all very fact-specific nuisance issues. And stuff like that it's not, there's no bright lines. It's very hard to regulate something like that and say, in every case, that's wrong, that's right. That's wrong, that's right.
Mm-hmm.
And so it's just by nature of life. Life doesn't work that way. Life isn't just completely black and white. There are shades of gray, and this is one of those areas. Mm-hmm. Okay? But I think with a combination of sound baffling, built-in politeness rules, controlling hours, and maybe not controlling amounts of people by not allowing outside, other than, a specific number of guests, of a member. Mm-hmm. Each member can have one guest at a time, that kind of thing. It could go a long way towards transversing that issue, okay, and resolving it, I think, okay? It's also going to be largely dependent on how your community is designed. Let me give you an example. There is in San Juan Capistrano, there's a private club called Marbella. Now, there are several neighborhoods within Marbella, and they each have sub-associations, and there's a master association. Mm-hmm. But if you are if you live in the association that's the connected condominium housing that's located near Marbella's tennis courts, you'll notice that surrounding some of those courts, there are multi-story, I think it's 3 stories. There are multi-story units surrounding several of those courts. Those courts in particular, if that court, as opposed to the outlying courts over here, were turned into pickleball, would be more problematic. And I think the HOA would have a harder time getting away with that because of the automatic increase. Mm-hmm. The sound is kept in an echo chamber, a stadium-like thing, just by being surrounded by condos.
Wow.
So if you have a choice to get a court that isn't surrounded and then convert a court that is, even if it's an outlier court, you're going to run into a reasonableness argument that I think homeowners could make to say, wait, you're doing this, that's not reasonable. You should be converting this. If you're going to convert the ones that aren't surrounded.
Yeah. That's
the kind of thing HOA has to take into account. Mm-hmm. I think you give homeowners arguments, even if they have the authority, you give homeowners arguments to argue reasonableness if you can make that sort of comparison. So the layout of your community is gonna play into this analysis.
And in other words, under that scenario you described, you are going at the business judgment rule or reasonableness of the board decision.
We're already deciding they have authority.
Yeah.
Question is, are they exercising it reasonably?
Yeah.
Now, there are some practical takeaways to this, okay? First of all, look at your governing documents. If you live in one of those, if your HOA wants to eliminate stables or something, and you live in a community that you thought was a horse community, maybe it is. Go look at your governing documents. We ran into a set of CC&Rs last week where the HOA could not do any conversions of tennis courts without getting a membership vote. Now, it was going to be a simple majority of a quorum. It wasn't like some supermajority like to amend governing documents or amend the CC&Rs, but it was there. And the HOA was not authorized to make that decision without putting it to a formal secret ballot, inspector of elections type vote, okay? Nice. So look at your governing documents, especially your CC&Rs, and determine whether or not they have the authority to make a conversion without your permission. If they do, then it transfers to, okay, is what they're doing reasonable under the business judgment rule and under just objective reasonableness standards. If they don't, you can stop them, okay? Here's the provisions in the CC&Rs you want to review. You want to review the places that talk about common area and common area authority over the common areas. Mm-hmm. If there are specific sections regarding use of recreational facilities, then you want to look at that section. You want to look at membership voting requirements to see if there's anything about these are the things that require a membership vote. It could be there. It could be in multiple places, but it could be there. And then maybe if there's a section requiring or talking about material alterations, whether it's the common area or exclusive use common area or whatever, if there's a section there. And those are pretty much the 4 areas in the CC&Rs. Mm-hmm. If you're going to find them anywhere, you're going to find them in one or more of those sections, okay? And if you find that your board is acting outside the law, either because they are barred from the conversion without the proper permission because of the governing documents, or they are exercising it in an unreasonable way that you think would run afoul of the law, and that is, for example, choosing the court surrounded by, multi-stacked condos instead of a court that isn't, then you want to attack this in a very rational, way, not frustration or emotion based.
True.
You want to communicate with the HOA instead of attacking them for being selfish or you guys are breaking the law and you suck and da-da. Say, hey, we have, 6, 10, whatever tennis courts. 3 of them are surrounded by multi-unit housing, which holds in the sound and creates an echo chamber, and 3 aren't.
Yeah.
Why are you converting the ones that are when you know that pickleball's louder? It automatically brings more people onto the same space, all that stuff.
Exactly.
Why are you doing that? It's not reasonable. Attack the problem, not the people.
Right. Do not undermine your own reasonableness and credibility
Exactly.
with visceral responses.
Exactly. And then, of course, document everything. If it happened verbally, if something happened by word of mouth and you haven't documented it in writing, it never happened, you never said it. Because under oath, they'll deny that conversation took place. So get it in writing, okay? Or if it's after the fact, confirm it in writing later. Now, if I'm an HOA board member, I want to look at all the issues we've talked about today. I want to represent all my constituents, all the homeowners in the HOA.
Yeah.
I want to look and see not just what's good for me. I'm a director that loves pickleball and I don't live anywhere near the courts. I need to look at what am I going to do to my neighbors and fellow members that live near the courts? And what can we do to eliminate or reduce the impact, the increased impact that this will absolutely have? Pickleball has more people, more noise. That's given. How do we reduce that? We can't prevent it. We can't eliminate it because it is what it is.
Right.
But how do we reduce it so that it doesn't cause a problem? A good HOA board member is going to think about that, and it's going to discuss that with his fellow board members.
Absolutely.
Those foreseeable impacts are things that good HOAs and good HOA board members need to take into account. And that's why I think an HOA should put it out there, saying, hey, we're going to discuss this at the next open meeting. We welcome anybody who wants to comment to come in. Let's have a discussion. So publicize that big time. Send out multiple emails. And then open the floor up. Maybe have general forum be much longer. Maybe it's even half the meeting that day to talk about this. What can we do to? I know Bob here lives right near the courts that we're going to be converting. Bob, what are your thoughts? That's the right way to do this. Not, there's a right way and a wrong way to handle things. That's the right way.
And the right way is a win for them too, because it covers them, arguably covers them more in terms of those anticipatory measures and the business judgment rule and things of, going above and beyond and trying to get the pulse of the community.
Right. Okay. Compromise, discuss, open it up. Those are what mature people do. That's what good people do. And you'll usually, look, ultimately somebody's going to be unhappy and somebody isn't, but if you can really, as Sam just said, you can really reduce the potential problems. If you go through the steps of opening this up for discussion and genuinely thinking through the foreseeable consequences and trying to address them. And then you have a built-in explanation to show why the business judgment rule, bam, totally in effect. Okay? Pickleball conversion disputes are becoming more and more popular nowadays because of the rapidly growing popularity of the sport. And because pickleball courts are built built very easily onto existing tennis courts with just painting on of additional lines, it's usually done via a conversion of tennis courts into pickleball courts, as opposed to finding some vacant land somewhere in the common area and literally just building pickleball courts. So it is a issue that is on and off the last couple of years become very hot item. There is a foreseeable impact when pickleball comes into play, and there's a lot HOAs can do. Even when they have the legal right to convert without membership approval, there's a lot they can do if they're a good HOA board to prevent misunderstandings and prevent people from feeling like they weren't heard. If you like this episode, please hit the like button. If you haven't already done so, please subscribe to our channel, HOA Hell. If you want to leave a comment, please do. Until next time, have a wonderful day.